Peace and grand rising to the Moors. maatkabba+vizer plus 999 plus 20250307, Empire State of Morocco, challenge of jurisdiction, Quo Warranto, Restitutio, Mittimus, Writ, exercise of constitution, treaty secured rights, Canaanland, Maghrib Aqsa, Northwest Amexem, white official, original status, Quo Warranto, Restitutio, Mittimus, place upon the public record, for the record and let the record show, international document, original and indigenous peoples documents for Moroc, Muur, Northwest Amexem, Morocco, North America, Northwest Africa, and all adjoining islands, the North Gate, Temple of the Moon and the Sun, non-domestic, non-resident, non-subject, Moors, being the rightful heirs, primogenitors, birthright, and inheritors of the land. Part 1. Peace and grand rising to the Moors. Moroccan Empire, United States for America, Moorish National Republic Federal Government, Societas Republica Elma al Marocos, Moorish Divine and National Movement of the Earth, Northwest Amexem, Northwest Africa, North America, the North Gate, and all adjoining islands, Temple of the Moon and the Sun, the true and de jure natural peoples, heirs to the land, Islam, I self-law, and master. Universal sovereign, original, indigenous, ancient, natural, divine, Quo Warranto, Restitutio. Challenge of jurisdiction, Quo Warranto, Restitutio. Notice to the principal is notice to the agent. Notice to the agent is notice to the principal. International document. The United States Post Office certified receipt. Tracking number of acceptance. 9589071052702047043078 and 9590940287954005520926. Chronos, the 7th day of the month of March in the year 1445, 2025, March 7th, Gregorian calendar at 8 antemeridian, Eastern Time. All rise and remain standing in perpetuity in accordance with the ancient laws as stated by this Holy Congress, cosmic progression of the sunset era. This is a sovereign, living, ancient, universal, Al-Moroccan, Moorish American Constitution for the United States, 1789, Article 3, Court Action. We are the sovereign, living, justice, anagel, todochea, saunders, in proper persona, surgeris, in proper solo, in proper herdis, in capitus nolo, and reading. My free chosen national appellations, angel, maatkabba+, in proper persona, surgeris, in proper solo, in proper herdis, in capitus nolo, and in reading. I and all Moors, the true and jure heirs for all land, all natural resources, all commerce, and all system. All Moors are the original, indigenous, sovereign, ancient, Al-Moroccan, Moorish American ascendants of the great pharaohs of Kemet and of the ancient Moabites and Canaanites. We are part and parcel of the sacred land, the sacred blood, and the sacred breath. The ancient Moors, Iroquois, Lamu Highlands, Kahiri, Tabaco, Exmaica, Las Maltese, Gala, and all natural, living, divine, original, indigenous, universal, sovereign, ancient nations, matriarchs and nobles. We are the great treaties of peace. Our full faith and trust, our allegiance, our credit, and our energy are hereby vested in ourselves, for we are the people who are the natural, living, divine, original, indigenous, universal, sovereign, ancient Empire State of Morocco, and the de jure Moorish National Republic Federal Government, Washington District for Columbia, the Universal Moorish American Consulate, and the Article 3 Moorish American Consular Court. We are the complete caput and corpus juris legalis, which is our statement that we are the lawful, legal, natural head and body for our empire. We are the most ancient sovereign court, both at heaven and at earth. Nous vivons. All Moors, the rightful, lawful title executors, ministers, heirs, trustees, claimants, beneficiaries, and possessors of the universal vast estate trust for our own vast estate. We are peace. We are one nation. We are one state, one empire, and one God. We are the most ancient sovereign court, both at heaven and in earth. We recognize ourselves and hereby accept our sovereign ascension, issue a sovereign creditor bill for possession, which is 9/10 of the law, and custody, which is 1/10 of law, over all judgment debtors. We exercise all sovereign rights at this time and all points in time. Exhibit A, notification for acceptance cover sheet, and 10, nationally autographed Moorish Saunders. Exhibit B, the Moorish American Consular Court, Article 3, challenge of jurisdiction, Writ of Quo Warranto. Exhibit C, sovereign universal living, alia, habeas, capitus and corpus, and quash, homonyms, anagel, todochea, saunders. Exhibit D, Moorish national identification card, anagel, todochea, saunders, MACN plus MA plus 999 plus 999 plus 025. Exhibit E, universal condemnation redemption, eminent domain law. Exhibit F, evacuation commands, Canada, Amexem, North America, Morocco, Earth, 2025-0221. Exhibit G, Sovereign Postmaster General Certificate of Service, maatkabba+vizer, maatkabba+vizer plus 999 plus 2025-0307. Office of the Ontario Superior Court of Justice Corporation, United States Corporation Company Agent, Jeffrey Morowitz. So Ontario Superior Court of Justice Corporation, subject Jeffrey B. Morowitz, 130 Queen Street West, Toronto, Ontario, M5H2N5. Carbon copy to Adult Matters, Toronto Case Management Courts of the Ontario Court of Justice of the Ontario Superior Court of Justice Corporation, subject clerk, care of 10 Armory Street, courtroom 806, Toronto, Ontario, M7A 0B9, delivered via return receipt, United States Post Office 95909402 87954005520940 and 958907105270204704704392, as well as Library of Congress, subject Carla Hayden, 101 Independence Avenue Southeast, Washington, District of Columbia, 20540. Regarding misrepresented instruments, Bill of Attainment Number, Foreign Bill of Exchange, Contract Case Number 468068 and 4810-99824-5 0001959 and 4810-99824-5 000195902 and 4810-998245 000195903 and any and all attachments associated thereto. Adult Matters of the Toronto Case Management Courts of the Ontario Court of Justice of the Ontario Superior Court of Justice Corporation. This is the statement. I, the undersigned clerk of deputy clerk, I, the undersigned clerk or deputy clerk of the above named court, authenticate pursuant to Versus Code 8.01-391C on the date that the document to which this authentication is affixed is a true copy of a record in the above named court made on the performance of my official duties. This is performance. Notice the principal is notice the agent. Notice the agent is notice the principal. The Moorish American Consular Court, Article 3, Writ of Quo Warranto, Jurisdiction, Venue, Fraud. International document. Quo Warranto, Mandamus, Restitutio, Mittimus. Notice the principal is notice the agent. Notice the agent is notice the principal. Place on the record, for the record, and let the record show. Available at https://1UYNMVR7BOITGRNGJUKI_4QFZIHE ? UPS equals sharing. So, whereas ex parte Angel Maatkabba+vizer, Aboriginal Moorish American national of the Moroccan Empire and rightful heir for Maghrib Aqsa, Northwest Amexem, North America, by justice inndigeneous, in full life, in proper persona, sur juris, being detained on the information of, in brackets, and capitalize, anagel todochea saunders, artificial fictitious name, from 2024 December 15th at 2 post-meridian to the date of 2025 January 20th at 12 post-meridian. Care of Ankh Triumphant El Estate, Canaanland Territorie, Northwest Amexem, Morocco. Ex Relations, 29 Louvain Avenue, Unit 313, Toronto, Ontario, M4M3M7. Phone 647-702-1916. Email todochea@protonmail.com. Plaintiff versus, and let's go into the other side, regarding misrepresented instruments, bill of attainder, foreign bill of exchange, contract case number 468068, 4810998245001959, and 481099824500195902, and 481099824500195903, and any and all attachments associated thereto. In the records of the foreign adult matters of the Toronto Case Management Courts of the Ontario Court of Justice on the Ontario Superior Court of Justice Corporation, care of 10 Armory Street, courtroom 806, near Toronto, Ontario, M7A0B9. Writ of Quo Warranto, international document, consular jurisdiction and venue under treaty law per Article 20 and 21 of the Treaty of Peace and Friendship, 1836, United States of North America, and the Moroccan Empire. Article 3, Section Diversity of Citizenship Cases. Article 4, Clause 2, Supremacy Clause of the Constitution for the United States of America. Inducement of fraud. Article 1, Section 1, Supremacy Clause of the Constitution of the United States of America. Titled United States Code 15, Commerce and Trades 1, Trusts, etc., in restraint of trade, illegal, penalty United States Supreme Court ruling, no corporate jurisdiction over natural man, case. Islam. So the plaintiff versus, and we are going to read the first and I'll then scroll through the rest for that to be visible on the public record on the screen. So plaintiff versus Jeffrey B. Morowitz, a foreign Occidental European male, acting as the custodian office of the Chief Justice and Judge, Ontario Supreme Court of Justice Corporation, Ontario Court of Justice Corporation, 130 Queen Street East, near Toronto, Ontario, M5H2N5. Writ of Quo Warranto, international document. Notice to the principals, notice to the agent, notice to the agents, notice to the principal. Exhibit B, the Moorish American Consular Court, Article 3, at State of Canada, Canaanland Territory, Northwest Amexem, North America, to wit. To all persons and offices. Subject, Jeffrey B. Morowitz, a foreign Occidental European male, acting as the custodian office of the Chief Justice and Judge, Ontario Superior Court of Justice Corporation, Ontario Court of Justice Corporation, care of maatkabba+vizer, Estate, Canaanland Territorie, Northwest Amexem, Morocco, X Relation 130 Queen Street West, Toronto, Ontario, M5H 2N5, regarding ex parte Angel maatkabba+vizer, Aboriginal Moorish American national of the Moroccan Empire and rightful heir for Maghrib Aqsa, Northwest Amexem, North America, by just sanguinis, in full life and proper persona sur juris, being detained on the information of, in brackets, in black and in capital letters, Angel Todochea Saunders, artificial fictitious name, from 2024 December 15th at 2 post-meridian to the date of 2025 January 20th at 12 post-meridian. Stare decisis law. A court cannot confer jurisdiction where none exists and cannot make a void proceeding valid. It is clear and well-established law that a void order can be challenged in any court. See Olwain METL Association v. versus Macduff 204 U.S.8 27 SCT.236 and 1907. For the record, and let the record show that I am Angel maatkabba+vizer, natural living person, in full life, in proper persona, in sur juris, a Moorish American national for the Moorish American, the Moroccan Empire. Our nationality citizenship is Moorish American, being an original and indigenous sovereign nation and national and heir for the Moroccan Empire, and foreign national inhabitant, a foreign national inhabitant, non-residential, non-domestic, non-subject, near corporate, Ontario, Canada, Republic, a reservation. We come now making a special appearance under duress as the authorized representative, ex relation, for the artificial corporate person, inndigeneous Angel Todochea Saunders. We hereby challenge your plural jurisdiction via Quo Warranto on the grounds of jurisdiction, improper venue, and fraud. I am natural living and divine Chief Justice Angel maatkabba+vizer, Matriarch Angel maatkabba+vizer, in capitus tonolo, in proper persona, in sur juris, in proper solo, in improper heredes, at all points in time non-pro-tunc. I am the descendant and ascendant of the great pharaohs of Kemet and the Moabites and Canaanites. You don't have jurisdiction over me, Angel maatkabba+vizer, and no United States Corporation Company citizen, which includes all government of, state of, province of, subdivisions, Canada, Ontario, Toronto, Ottawa, London, the U.S. Federal Reserve, which includes all U.S. Federal Reserve debt notes, Bank of England debt notes, Bank of Canada debt notes, Canadian dollars, sterling pounds, and all heirs, assigns, principals, and agents, and any and all derivatives thereof, as personam jurisdiction, nor territorial jurisdiction, nor subject matter jurisdiction over an aboriginal, indigenous, ancient, original, divine, Moorish, Moroccan national at any time, non-pro-tunc. Jurisdiction and venue. I hereby invoke my secure treaty rights to consular jurisdiction in this dispute under Article 20 and Article 21 of the Treaty on Peace and Friendship of 1787 between the United States of North America and the Moroccan Empire, and hereby repress all unlawful court action pursuant as follows. Article 20. If a citizen of the United States or any person under their protection shall have any dispute with each other, the consul shall decide between the parties, and wherever the consul shall require any aid or assistance from our government to enforce his decision, it shall be immediately granted to him. Article 21. If a citizen of the United States should kill or wound a Moor, or on the contrary, if a Moor shall kill or wound a citizen of the United States, the law of the country shall take place, and equal justice shall be rendered, the consul assisting at that trial, and if any delinquent shall make his escape, the consul shall not be answerable for her in any manner whatsoever. whatever. In support of my secure treaty rights, see case Kolovra versus Oregon, 366 U.S. 187 194 81 S CT point 922 in brackets 129, where the Supreme Court of the United States rendered the following stare decisis. A state cannot refuse to give foreign nationals their treaty rights because of fear that valid international agreement may possibly not work completely to the satisfaction of state authorities. Under the Supreme Clause of the United States Constitution, Article 6, Clause 2, state policies must give way to the overriding federal treaties and conflicting arrangements. Fraud. All government entities and alleged private corporations must be creatures of the American Constitution, since corporations cannot exist without the consent of the state. All issuance of bills of attainder are inducements to fraud, conspiracy to defraud, and misrepresentation of treason, extortion, etc., and are in violation of Constitution of the United States, 1789, Article 1, Section 10. No state shall enter into any treaty, alliance, or confederation, grant letters of marque and reprisal, coin money, emit bills of credit, make anything but gold and silver coin, attender in payment of debts, pass any bills of attainder, ex post facto law, or law impairing the obligation of contracts, or grant any title of nobility. Title USC, United States Commercial Code 15, Commerce and Trade 1, Trusts, etc., in restraint of the trade illegal penalty. Every contract, combination in the form of trust or otherwise, or conspiracy in restraint of trade or commerce among the several states or with foreign nationals is declared to be illegal. Every person who shall make any contract or engage in any combination or conspiracy hereby declared to be illegal shall be deemed guilty of a felony, and on conviction thereof shall be punished by fine not exceeding $100 million if a corporation, and if any other person, $100,000 $1 million, or by imprisonment not exceeding 10 years, or by both said punishments in the discretion of the court. Whereas, inasmuch as every government is an artificial person, an abstraction and a creature of the mind only, a government can interface only with other artificial persons. The imaginary, having neither actuality nor substance, is foreclosed from creating and attaining parity with the tangible. The legal manifestation of this is that no government, as well as any law, agency, aspect, court, etc., can concern itself with anything other than corporate artificial persons and the contracts between them. Any court of probate, in the exercise of this jurisdiction over the probate of wills and the administration estates of deceased persons, has no jurisdiction to appoint an administrator of the estate of a living person. The state is prohibited from violating substantive rights, and it can not do by one power, for example, police power, that which is, for example, prohibited expressly to any other such power, taxation, eminent domain, as a matter of law, nor indirectly that which is prohibited to it directly. Islam. Quo Warranto. You, plural, are hereby commanded to produce the following for the record as conclusive proof and evidence of your lawful jurisdiction and judicial authorization. Number 1. Produce the certified copy of the delegation of authority from the Congress per Article 3, Section 1 and 2 of the Constitution for the United States of America as evidence of the private foreign entity, and here's the list. Please read it, it's on the public record. being associated with conclusive action in the misrepresented instruments, bills of attainment, foreign bills of exchange, contract case numbers 468068 and 4810998245001959 and 1810998245000195902 and 48109824500195903 and any attachments associated thereto. Number 2. Produce the alleged Fourth Amendment lawful arrest warrant being signed and issued by an Article 3 judicial officer or consular officer and the probable cause associated being signed under oath or affirming by alleged identifiable natural persons to be the plaintiff, accused in the case number contract case number 468068 and 48109982450001959 and 48109824500195902 and 48109824500195903 to satisfy the requirements of standing pursuant to stare decisis law, Allen versus Writ. The requirement of standing, however, has a core component derived directly from the Constitution. A plaintiff must allege personal injury fairly traceable to defendant's alleged unlawful conduct and likely to be redressed by the requested relief. As the alleged injured party/victim, in support of the lawful warrant, which ordered for the arrest of our Moorish American national anagel maatkabba+vizer, and not the fictitious artificial name inndigeneous, anagel todochea saunders in capital letters in black ink and in brackets, race, black under color of law, which constitutes fraud. Number 3. Produce a certified or true test copy of any alleged valid and verifiable contract or commercial agreement between any representative of the foreign entity. And I, which would subject me to any specific performance or to any corporate color of law, statute, code, rule, regulation, or custom of the private foreign corporate entity, Ontario Superior Court of Justice, and any subsidiary thereof. Ontario Superior Court of Justice Corporation and any subsidiary thereof. And number 4, produce the name and telephone number of the public hazard and malpractice bonding company and the policy number of the bond, and if required, a copy of the policy describing the bonding coverage of the specific job performance of you, plural, and all other natural persons acting as employees, agents, representatives, contractors of the foreign corporate entities. Being associated with conclusive action in the misrepresented instruments, bill of attainment, foreign bills of exchange, contract case number 468068 and 48109982450001959 and 4810998245000195902 and 4810998245000195903 and any attachments associated thereto. Number 5. Produce proof of allodial title to my ancestral estate in revision known as Ankh Triumphant L Estate, Canaanland Territorie, Northwest Amexem, X Relation, 29 Louvain Avenue, Unit 313, Toronto, Ontario, M4M3M7. Number 6. Produce proof that lawful services of process was made upon me regarding the misrepresented instruments, bills of attainment, foreign bills of exchange, contract case number 460868 and 4810998245000 1959 and 481099824500 195902 and 481099824500 195903 and any attachments associated thereto in the records of the foreign Toronto Case Management Courts of the Ontario Court of Justice of the Ontario Superior Court of Justice Corporation, care of 10 Armory Street, Toronto, Ontario, M7A 0B9, in accordance with the prerequisites of due process of law under the Fifth Amendment of the Constitution for the United States of North America and the United States Department of State Consular Notification Access Manual, 5th edition, 2018, requirements.